Hello, everyone. Welcome to Police Reform and Accountability, How the Public Keeps Tabs on Our Police System. My name is Molly Boigon. I'm an investigative reporter with The Forward, and we're thrilled to have you here today. I am being joined by Joseph Aron, an attorney at Aron Law, who represented The Forward in a successful record suit against the NYPD. Hi, Joey. And also Eric Umansky, the deputy managing editor of ProPublica, who has written about police discipline. Hi, Eric.
Hi there.
Thank you both for joining us. So I'm going to ask the guests to introduce themselves in the chat while we wait for people to trickle into the Zoom. And for those of us who are joining on Zoom, I'll ask you to please drop any questions you may have in the Q&A, which you can find at the bottom of your screen. Okay, so I think we'll get started and we'll just let people continue to trickle into the Zoom. Today marks a year since the police killing of George Floyd, which sparked protests across the nation. Newsrooms continue to be focused on holding police departments accountable in the wake of continued violence against Black Americans. And as hate crimes against Jewish Americans spike following violence in the Middle East, people are interested in how departments handle attacks on Jews. So The Forward has been working on this subject for a while, but we got involved in FOIL record suits against the NYPD in 2019 after a spate of violent crimes against Orthodox Jews in Brooklyn. And we originally asked the NYPD for police reports, investigation files, body camera footage, surveillance videos, photographs, and interview transcripts. Those requests were denied. We eventually whittled our request down to just 4 forms over the course of 2 years, only in the borough of Brooklyn and just for crimes that went beyond graffiti. And those were still denied. So we wrote a piece essentially publicly shaming the NYPD for refusing to grant access to public records. And then we teamed up with Joseph Aron, who's here with us in the Zoom, to sue for those records. We won and wrote a story about those findings. And so I'd like to talk to Joey a little bit first about what you made of that case and whether you think it's common for the NYPD to decline to hand over public records.
Sure. So hi, everyone. My name is Joey Aron. I'm an attorney primarily focused at this point in litigating in relation to the Freedom of Information Law. So essentially what happened it's hard doing this virtually because can't really have so much of an interactive thing, but I'm sure many of you have made various requests with the NYPD, and you may have realized that it's sort of the war of attrition. And I say that because the statute is very generous, perhaps one of the most generous in the country, and if you're willing to go the distance, so typically the statute really does what it's supposed to, and it really gets you a broad array of material, of documents. So in this case, what happened was the Forward wanted to get some actual detail about the anti-Semitic hate crimes in 2019 from the NYPD and made a request. And what should have been basically a routine request for general records about arrest reports and different allegations turned into a whole litigation. Eventually, we got almost all the records. I guess we could talk about exactly what exemptions were raised and how we responded. Or Molly, do you have a preference on how we go forward? Or
yeah, let's get into that a little bit, those specifics a little bit more later on when we talk about some of the department's tactics for denying requests and declining to provide information. But Eric, I'd also love to just get into a little bit, you've covered police discipline widely, and you've also had, sort of a more personal experience dealing with the NYPD declining to provide information for an event that you actually witnessed. I'm wondering if you could share that story.
Sure. So thanks for having me on this. I am actually not, have not typically been a reporter at ProPublica. I've been an editor. And as you mentioned, I came into this all in a kind of personal way. It was actually Halloween in 2019 when my wife and our then 6-year-old daughter were coming back from a friend's house and trick-or-treating, and saw a NYPD car go the wrong way up a street and hit a teenager. And the teenager, who was Black, actually went across the hood, jumped up, ran away. They were trying to pursue him for something. And then the police turned their attention to other Black boys who just happened to be standing nearby and didn't have anything seemingly to do with the other young man. And my wife watched all this and actually came back home and got me and said, it's really upsetting. You should see what's happening here. And I went out and I saw these other boys arrested, and I actually waited at the precinct with their families while they were held for hours and then were released without any charges. It seemed quite clear that the police had frankly racially profiled these kids and had no basis for holding them and left them. And so afterward, I was sort of puzzled by all this, and I contacted the NYPD, and I basically just said, help me understand what happened here. Was there some problem? What are the policies, for example, of going the wrong way down a street? And what the NYPD eventually told me was, in short, your wife and daughter didn't see what they thought they saw. That in fact, a car did not hit a kid. This is my phrasing, the kid hit the car. The kid ran over the hood of a stationary car. And I then actually started canvassing people in the neighborhood and found 3 other witnesses. And I realized that the NYPD, I said to them, you're really going to tell me that 4 people, including my wife, saw something, and you're just going to tell me it didn't happen? And they said, yeah, that's right. And I tried to get more information on the case, and I couldn't get more information on the case. And I just was left kind of puzzled by it all. I was actually left with a feeling of, if you can, frankly, BS me, who's honestly in a position of some power, I can write about this stuff. You must really sort of feel like, you don't have to answer to people. And that started getting me digging.
Yeah, and in reading your piece about that, it was clear that one of the issues with holding departments accountable is that they have so much discretion in deciding what to provide and what not to provide. And Joey, maybe that's a good segue to talk about some of the denials that we were issued, and some of the logic that we thought could be used to combat those denials.
Sure. So you said something very well in terms of them exercising discretion. So I would like to address that, because really what FOIL is sort of a presumption of public access to records. Like some people say, they're our records or the people's records. And technically speaking, in terms of the law, any request you make, you're really entitled to, unless the NYPD could demonstrate that the records you're requesting are exempt. So in other words, in the perfect world, it should make FOIL a lot simpler, because the presumption is an entitlement to the records. And legally, the burden is on the police department to show that the records you're seeking are actually exempt as a matter of FOIL law. But I'll describe what we went through and what a lot of people went through. There's really two types of FOIL cases. And the two types are FOIL cases where the agency really wants to litigate an issue, meaning they'll say there's an exemption and you'll say the exemption is misplaced. And then there's the other type, which I really call the war of attrition, which is, the FOIL process is you make a request. It's very simple. Agencies are required to have their email address or portal on their website by law. You make a request and they respond. Now, some agencies are worse than others, but very often the NYPD will just, it seems at random, say, your records are exempt because of ABC. Now, in the FOIL process, there's what's called an administrative appeal. So then what happens is you administratively appeal, and very often the NYPD will say, well, we reviewed, your request and your basis for appeal, and you're right. ABC was misplaced, but it's exempt because of X, Y, and Z. And then what will happen is you'll look at X, Y, and Z, and you'll say, hey, X, Y, and Z also makes no sense. And you'll commence an action, you'll sue. And the day you'll sue, they'll call you on the phone and they'll basically say, we're ready to play ball. You could have at least some of the records. And with the forward, I think we're now by lawsuit number 3 with the NYPD. And with the first one, I think that's what it was. There really wasn't an issue. It was a little crazy because, there was tremendous public interest at the time with the anti-Semitic hate crimes. And when we sued, so for the overwhelming majority of them were released in the first action. So that's one type of FOIL action. In other words, it seems like you have a pretty clear entitlement, but you just have to play this game and go through these various steps. Now, it's really unfair because traditionally, the step that actually gets you the records is to sue. And for a very long time, it wasn't practical for a regular person because everybody knows the resources required for an actual lawsuit are significant. What happened was New York, I think it was in 2017 or 2018, like many jurisdictions, has a fee shifting provision in FOIL. And what the legislature wanted to do was, and this is very common in civil rights actions, encourage attorneys to take FOIL cases. And they did that by creating a piece of legislation that essentially says, if the agency had no reasonable basis and you substantially prevail in obtaining the records you sue for, the court doesn't have any discretion and must award attorneys' fees and costs, which essentially makes you whole from your litigation. And it makes sense because it's two things. It's an incentive, and it may even be considered by some as punitive to the agency because the legislature realizes that FOIL is a very important part of a democracy. It's
Right.
exponential for a journalist. I'll just finish off. Sorry, Molly, cut you off. With
It's okay.
The one last point with FOIL is it's all good, and what the forward did was fabulous. But when the NYPD makes you run through these hoops, what it does is you had a story at one point which everyone was Googling and clicking all day, and they want information on. And by the time you get the records, for lack of better term, they're somewhat stale. And that's something that has to be fixed legislatively. An attorney could sue, we could get the records, but it's extremely sad that they have the ability, and the court system is notorious for just schlepping forever, that by the time you get it, regardless of what type of investigative story a journalist is doing, it's not going to have the same value as it had at the time you made it. And that's just an extremely unfortunate piece. I'm sorry, Molly.
Yes. No, that's fine. Yeah, no, well said. And I think, as you said, for most people, a lawsuit is not an attractive option. And I know, Eric, we talked a little bit before about how there are some other strategies that people can use to get information when the police department is sort of being, withholding information. Some of the reporting processes that you went through using city agencies like the CCRB. Can you talk about some of those types of options?
Sure. So we actually ended up having luck with, you just mentioned, this agency called the Civilian Complaint Review Board that basically has a lot of records and is independent of the NYPD, and that has historically been far more responsive. in terms of FOILs. I will say, my experience with NYPD FOILs is it's like a little bit like writing Santa. I write and then I don't really expect a response. I'm a good Jewish boy. I never actually wrote Santa in practice, but conceptually speaking, but we had some luck over last summer where we filed a request for records that lots of people were doing it via the NYPD, and we happened to do it via the CCRB and ended up with a kind of whole collection of records that had never previously been disclosed. So yes, we got around the NYPD in that sense and got kind of lucky.
Yeah, and I think that's also an interesting thing to highlight, that records are public at pretty much every stage of their movement through the government. So the fact that you were able to access them through the CCRB rather than through the NYPD is also an option that people should keep in mind. We had a great question from Dennis Guillaume, hopefully I'm not botching your last name, who asked about reforms and restructuring as a result of local organizing. So I think, maybe a nod to 50A, which we'll get into in a second, but he asked, is local organizing for local change, including data transparency, counterproductive to state and national efforts, or does it matter? Let's go to Joey first. Do you have any thoughts on that one, Joey?
So I'm not really sure the context of the question in terms of the organizing, in terms of lobbying, like for legislative changes, or just?
That's what I understood it to mean. The full text of the question is, reform/restructuring is proposed at the national and state level with some success. Some
Right.
local success has also been reported too. Is local organizing for local change, including data transparency, counterproductive?
Oh, I think lobbying and advocating is obviously golden. I mean, eventually every legislation is to some extent a reflect of the will of the people. I think you definitely see that with 50A, which this Zoom now is to talk about NYPD. There's no more bigger development than 50A, and 50A was talked about, the repeal of 50A for probably decades through every administration, and I think due to current events and public outcry, 50A was repealed. So there's no question.
Can you just explain for people who don't know what 50A was?
Sure, absolutely. So we brushed over earlier that FOIL is subject to exemptions, and those exemptions are really in two forms. One is they're statutory within FOIL. Like FOIL will say, well, if something's an invasion of privacy, if it will interfere with a current judicial proceeding or investigation. And obviously each of these exemptions themselves are subject to immense amount of case law interpretation. But one of the exemptions is that a document does not have to be provided in response to a FOIL if it's exempt by another statute. So there was a statute on the books for years called 50A, which essentially exempted personnel records from certain employees. In particular, I think it was police officers, firefighters, correction officers. So anytime there was a request for a disciplinary history for an officer, that request would be denied based on the official exemption was 87-2A, because there's another statute that speaks to those records and insulates them. Now, there was, just go off the tangent for a minute, there was an interesting court case in 2018 from the New York Civil Liberties Union that made its way up all the way to the Court of Appeals, which basically said, hey, those personnel files, which mean they relate to an officer, are exempt, but let the NYPD redact any identifying information, which of course is subject to debate itself, what information would identify, and then give the records. And the court said, no, if it's subject to another statute, the entire record, regardless of whether or not it could be adequately redacted, is subject to withholding under FOIL. So what happened was this 50A provision was repealed. Now, when it was repealed, there was a lot of fanfare because the knee-jerk reaction was, oh, now we're going to get disciplinary records for officers and anything else that relate to public officers. What happened is there was a significant amount of pushback by the NYPD, and they said, look, there's no more 50A, in disciplinary and personnel records in of themselves are subject to FOIL now, but there's another exemption called personal privacy. And when you have allegations in particular that are unsubstantiated, that should sort of implicate a privacy interest for the officer because it could affect his career, his personal stuff and whatnot. And therefore, even though they're no longer withheld by statute, let's look at this other statute that says personal privacy and apply it. And Eric could probably speak more to the practical manifestation of the current state of events.
Yeah, Eric, I'd love to hear from you about that.
Sure. I mean, the current state of events is there's a lot of information that's not being disclosed. It is one of these sort of unfortunate things, which is that indeed this law was passed to repeal this secrecy, and actually police unions and other unions fought it vociferously. They lost. They lost quite definitively, and in turn, what happened was, and it's a little bit of, it is a mixed picture, but one of the things that happened is that because of things Joey was saying, the NYPD put out a database that is, sort of inexplicably limited. You can look up even sort of officers with well-known records, and you find that they're not simply just not in the database, not in the database. And again, you have this option to, for example, go to CCRB, which has some information, but it is very difficult, and you need to be kind of an expert to navigate all these different places and all this different information. It's it makes simple transparency and accountability very challenging.
Yeah, and the ProPublica has made available and searchable some of those records. I think I did. If someone from the forward could drop, I can't remember if I sent you that link. I think I may have, but if not, we'll track it down after and send it around. I'd love to hear from you both about, obviously, the conversation around police accountability has changed significantly over the last few years. And both of you have been in this space for a while. I'm wondering if you've noticed any change in either direction, and in terms of either more or less transparency over the years from the NYPD. Eric, why don't you start?
Well, so I have to say, I'm something of a newcomer to this because, I started digging in last year. I will say that, the truth is, from my own experience, the big picture is it is extraordinarily difficult to get information from the NYPD about, for example, particular cases. I can speak to an example. I'm happy to go to Joey, but the big picture is it's very, very difficult.
Joey, what about you? Any thoughts on that?
A couple comments. I'm not really sure what you meant, Eric, by specific cases. Do you mean cases that are ongoing?
I actually mean cases in a journalism term, not in a legal term. So a couple of incidents and so forth that we've looked into, for which we've long requested information, that are sort of indicative of how slowly information comes out and how difficult it is to get information.
So let me address that in a couple different ways. So one is, and I think it's good for everyone on, because they obviously have some interest in foiling the NYPD. So one of the exemptions in general in FOIL that's particularly relevant with the NYPD is if a record will interfere with an investigation or judicial proceeding. And the reason why it's irrelevant, because if you're a journalist or just somebody who reads the news and you want to know more about a story, more often than not, you'll see, oh, such and such happened and so was arrested, and you'll say, wow, let me get the complaint and the arrest report. So that probably is one of the most common type of things that would be foiled from the NYPD. Now, what the legislature did, and it sort of makes sense, is said that if something's going to interfere, which in simple English means it's going to mess up an investigation or it's going to mess up a court case, you're not entitled to that record, because obviously the public interest in having an investigation or having a court case overrides your interest in a record. So there's definitely a legitimate and logical basis behind it. What from my experience, what tends to happen is this: anytime there's any case going on, they'll immediately tell you it's exempt because there's an investigation and therefore will interfere. Now, the statutes in the court specifically say that it has to interfere with the investigation, meaning the mere fact that there's an investigation alone is not symbolic to the extent that, oh, therefore you shouldn't get it. They have a burden to show interference. It's a low burden, but they have a burden. So what we recently did, and we're in the middle of arguing for the forward, is this. Last year, there was this new whole bail reform and an amendment to the criminal procedure law. I think it's called 265. One of those amendments was that if somebody's charged with a crime, they're basically immediately entitled to all the witness information and everything else that the prosecutor has. Now, what we argued for the forward was, they're saying they're not giving it because it would interfere with an investigation. But we're asking for complaints and witness accounts, which were given over to the alleged perpetrator. So if the perpetrator already has this information, how could the NYPD make a case that the forward's knowledge of the information is going to impact the prosecution? In other words, the guy you're prosecuting, he himself has the information. So what could the forward do to interfere? That's our argument, and that's pending now in the court. We made a similar argument for a different media company last year, which was about a motor vehicle accident, because there's a analogous law called Public Officers Law 66A, which says motor vehicle accident reports are open to the driver themselves, and therefore we argued to the First Department that once the driver is entitled, the newspaper should be entitled. And the court liked that argument, and the court said, since the accused is entitled to the report without any preconditions on releasing it, so the newspaper should too. You can't make an argument that there's interference. So I think it's a very good argument, and I think it's really appropriate almost any time that you ask for stuff on a pending investigation where there was someone who, a suspect or whatnot, someone who was already arrested and he got the information. If he could get it, why can't you get it? So this interference is a big thing. Another thing that plays regularly that we were talking about a little bit before we went live here with the Zoom is, I'm not sure the level of familiarity, but in low-level criminal stuff, very often the proceeding will result in a sealing. So by law, if somebody has something sealed, so that means the file is sealed, and it wouldn't be subject to FOIL because it's Criminal Procedure Code 160-55. So it's very interesting because if you make a request, once this thing that you want to get data on has ran its course, there's a very good chance that the file will be sealed, and therefore the NYPD, I'm not sure if it's right or wrong, but it seems like there may be some merit to it, will say that the entire thing is sealed. I say I'm not sure because the statute says the official record is sealed, and there's a bunch of case law trying to interpret what an official record means. So parts may be sealed, parts not. But when you ask for stuff that is subject to an investigation or judicial proceeding, these are the two things that invariably will come up, that it will interfere and that there's another statute that exempts it, which is the sealing statute. So
yeah, I think you're touching on something interesting, Joey, which is that I think if you're sort of new to this process, the exemptions may sound, completely legitimate and without grounds for dispute. To say, for example, that disciplinary records might violate somebody's privacy, or to say that that a record is exempt from disclosure because releasing it would interfere with an investigation. I'd like to go to Eric for this one to see how journalists and everyday citizens should think about balancing the public's right to know and the principle that these records belong to the public with some of these concerns that are brought up either in good faith or in bad by the department.
So I think it's helpful to sort of to ground this in some real world examples of how it's played out. And there's one case that I've been reporting on that I think speaks to a bunch of this, and it's about a young man whose name was Kowalski Trawick, and he was killed about 2 years ago in his own home after police came to his door. He was in a sort of kind of mental health crisis. Police came to his door. He was holding a bread knife, and they ended up shooting him 112 seconds after they got to his door. He hadn't attacked them. And it was a very sort of questionable shooting, one that was worthy of scrutiny, and just trying to find out the underlying facts. And the NYPD, I mean, I just want to move beyond the specifics of the law to the sort of general question of transparency and accountability. The NYPD basically said the only information that they gave was the morning after the shooting, where a commander said, look, this was a hard case. We think it was justified, but we're investigating. And for the next nearly 2 years, or a year and a half, they wouldn't release any other information. They wouldn't release, for example, one of the officers had body-worn camera on him, and that recorded the whole event. They declined to release that footage that showed exactly what happened in those moments. They actually wouldn't show it to the family of Kowalski Trawick for a significant period of time. And their reasons there were citing respecting the privacy of the deceased. So it was a kind of brain twisty, they wouldn't show it, citing the privacy for Kowalski Trawick. The NYPD had never actually asked his family for permission. They could have said what they were concerned on that front. And they also had cited this question of interfering with an investigation. But again, there were no specifics for that. And after a year and a half, one would have thought that they would have been able to do the basic steps of an investigation. But in fact, it kept being held up. They actually fought a lawsuit against releasing it. And they ultimately did have to release a whole bunch of footage after, frankly, significant public pressure and lawsuit. And by the way, what the footage had showed, what the footage does show, is that one of the officers had tried to stop his partner from shooting Kowalski Trawick. Had actually said, no, don't, even pushed his gun down. And that his partner decided to do it anyway. I mean, it raised significant further questions. So that's just a sense of what this stuff can mean in practice.
Yes, and I think the Kowalski Trawick case touches also on something that we brought up briefly earlier, which was the fact that investigations by journalists and by city agencies can take a very long time. And, in this case, there were revelations as a result of the body camera footage that might have changed the course of I guess the department did have the body camera footage, but, it would have meant different things for accountability in that case. I would just love to hear from both of you, maybe Eric first, about how people should think about that problem and you know, whether there's any kind of creative solution to deal with the persistent delays in getting information and you know, and having that information be released.
You know, I think it is honestly hard for an individual citizen to you know, address that on an individual basis. I think that the solutions to that are ultimately political, are, you know, ultimately about the representatives who one elects and what they demand. You know, I think at the end of the day, and there are some groups that advocate around these issues, by the way, I should say, both sort of transparency groups and police reform groups. But, you know, at the end of the day, this sort of goes to the sort of fundamental question of who's in charge of the police. And is it really the sort of civilians who are in charge, and how does that actually play out on a day-to-day level? And the people in a position to change how that plays out are our city leaders, ultimately.
Yeah, Joey, can you speak to that question as well?
I'd just like to speak a little bit to this story with the privacy about the body cam footage. It's interesting because a while back, I think it was a 2013 case, and in New York, it's a little bit of an anomaly. The lowest court is called the Supreme Court, and the highest court is called the Court of Appeals. There was a case in the Court of Appeals. I think it was the New York Times against the fire department, and it was for 911 calls on 9/11. And also, it must have been before, I can't remember the year exactly, but what the court found was that there was a privacy interest in those calls. And the court also said, and I didn't read the other decision, but the court also said, you know, when there's a privacy interest, so what you do is you balance the privacy interest against the public interest. And I don't know if that was why the NYPD case resulted the way it did, but it's interesting that that's how you look at it. In other words, that case they lost because there was a privacy interest, and the NYPD case apparently, you know, the NYPD lost, perhaps because the public interest, the court found, superseded that privacy interest. I'll also say that the case law says consistently that a public employee has a lower level of expectation of privacy than an individual. And that may have also been a factor that played out in those two cases. FDNY was recordings from private citizens, whereas the body cam footage was, you know, primarily, I guess, this other officer. I'm not really sure.
Right, and so in that case, it's a private citizen versus a public employee, and that might have impacted the decision.
I'm not sure, right? I didn't read that opinion, but I'm just sort of thinking out loud and just sort of, you know, talking about some of the different variables and some of the different elements. And I think the privacy exemption is really the most difficult to litigate. And if there really is something there to privacy, you're really going to have a hard time because it's something that's purely subjective. In other words, some of the other exemptions, there's much more of an objective piece that they have to show. And I think just the nature of privacy is really much more subjective. Although I will say privacy in the context of FOIL, you know, there's some line that's thrown out. I don't know it verbatim. If a regular person on the street would think that that's something you'd want to keep private, that implicates the privacy exemption. I don't know that that gives you much more of a flavor, but that is official litmus test of, you know, when it could be invoked.
Right. I want to remind people that they can drop questions in the Q&A. But before we get to some of those, Joey, you said that one of the solutions to the delay problem is legislative. What would something like that functionally look like?
So I think there's two aspects to the delay. One aspect is in the agency, and I think anybody who's made a FOIL is aware of this aspect. This aspect is you make a FOIL request, the law requires them to acknowledge the request within 5 days. Any agency that knows what they're doing, you know, if they have more than 2 people working for them, even if it's some village in the middle of nowhere, they're going to follow that and they're going to give you an acknowledgement within 5 days. what agencies who know the tricks do regularly, some of the larger city agencies that journalists deal with every day, they have this form letter that says we're very, very busy, especially since COVID. So expect a response in 6 months. One day before 6 months, they'll say, oh, we're still very, very busy, and of course we're understaffed. So expect a response in 6 months. Now, there's no provision in FOIL that really says, you know, on X date, you're done. So they just give extensions forever. Now, under certain circumstances, extensions are justified. So I think one of the things that could be done is there could be some concrete deadline put into the FOIL statute. So that's in terms of the agencies. The second aspect is, even if an agency gives you a determination, an adverse determination, and now you've exhausted your administrative remedies and you can go to court and commence an Article 78 and compel the agency, the problem is, well, let me take a step back. It's very interesting because this type of proceeding is called an Article 78, and under the CPLR, it's known as a special proceeding. It's supposed to be accelerated. Notwithstanding the fact that it's a special proceeding and it's supposed to be accelerated, it could stay on literally for years. We're still litigating 2018 FOIL cases with a 2018 docket number, meaning the request could have very well been made in 2017. So it's a little bit ridiculous. You know, the legislature had in mind 5 days for this, 20 days for this. Meanwhile, here we are 4 or 5 years later and we still don't have the documents. So what the court system could do legislatively, in certain contexts, there's something called preference, that the law requires a court to say, hey, we have busy calendars, but this type of matter goes in front of everything else. And there is limited circumstances that applies to FOIL now, but it's on appeal in the court system, not in the agency. So on the trial level in the Supreme Court, it could sit for 3 years. The judge could just be waiting. It doesn't get preference, and there's no requirement by law that the judge makes a decision within a certain amount of days. So I think those are simple. I don't want to say simple because obviously nothing legislatively is simple, but those are fixes that would move it and make it more productive. I think something else that FOIL could use is in the federal equivalent, which it's modeled after FOIA, there's some specific statutory stuff. I don't know if it's specific to journalists or it's for journalists, that you could sort of say, you know, we have a special reason why this should move, and the court has to move it because of that reason. It may even say it's for journalists, and I assume the reason is because it was contemplated that the information, you know, if you wait, it's stale and it's worthless. And the whole idea of FOIL is to, you know, let people know what's going on. So I think adding concrete deadlines for the administrative agency and adding something in the CPLR to give preference or some type of court rule to FOIL cases is something that would help in getting documents sooner than later.
Yeah, that makes sense. You know, yeah, imposing some more strict deadlines on agencies. We got a question about whether or not there are material differences in how New York City mayoral candidates might address police accountability. I don't feel really equipped to answer this off the top of my head, but I know that Eric Adams, as a former police officer, has spoken, you know, vocally about making it easier for police officers themselves to report colleagues who engage in bad behavior. Eric, I'm wondering if you have any thoughts on that off the top?
Yeah, you know, it is something that I've looked at, and it sort of falls onto, I think, kind of in 2 different areas. One is where candidates really have quite divergent opinions, and you know that is primarily around issues you know, that are kind of characterized in terms of defunding the police. You know, should resources be moved away from the police and toward other city services? In a funny way, that to me, I actually think can end up underplaying just how much of a consensus there is, or how much agreement there is on a number of other sort of fundamental issues. So, you know, and there are permutations of this, but really all of the candidates acknowledge that that there needs to be more accountability in the system, that there needs to be more transparency in the system. Now, whether that's sort of lip service on their side and whether, you know, they're really going to deliver, you know, I think are very fair questions. But there is, and I think that this is perhaps different than in, you know, other years, a acknowledgement that simply maintaining the status quo is not sufficient.
Yeah, Joey, I don't know if do you have thoughts on the mayoral race question or on this? You know, I think what Eric just said is also worth some reflection and then discussion.
Yeah, I'll just say like this. Before Mayor de Blasio was mayor, he was public advocate. And one of his pet peeves, and he actually did a report on it, was how lousy agencies are when it comes to FOIL. So I don't think that's changed. When he was public advocate, I know it was a huge issue. Now, you know, these are, you know, the agencies we're talking about, NYPD, it's a mayoral agency. So, you know, I think they sing one tune until they're there. Ironically, the first FOIL case I ever did was against the New York City Department of Education. And in that case, what we did was we actually cited Mayor de Blasio's report as then public advocate because it was a mayoral agency. And we said, look, here's what he thinks. So, you know, I don't know how much of a difference it makes in this day and age. I don't think anybody's going to trash FOIL. Obviously, the climate is such that, you know, FOIL is important. And I think you're going to hear that a lot.
Right. Yeah. I think that this conversation to sort of a person who's not in journalism or in the field of law might be intimidating, and really public records law is designed to be accessible to the public, not necessarily people who have, you know, all of the time and energy and savvy that all of us have. And I'm wondering if either of you, let's start with Eric, might have thoughts on what everyday citizens can do to increase transparency and accountability in the department.
I mean, the truth is, I think primarily that comes with your vote and your voice. You know, I actually have a friend who is works in politics in New York City, and one of the things that she said to me is, you know, if if just a few people call their city council person or local representative, it gets their attention. If it's a dozen, it's like a crisis. And so, you know, if people feel passionately about an issue, you can contact your local representative, and, you know, it actually does have the ability to make a difference. It also is, to echo Joey said earlier, you know, if you, and this can be more, you know, if you are simply interested or whatever, you can actually file a FOIL on your own. It is truly meant for citizens. It's actually not really complex. And actually, if you Google like FOIL generator, there are ones that sort of automatically help you. I'm sure they're not your quality, Joey, but nevertheless, you know, it's very basic things. And, you know, you never know. People can see it's you know, it can help. You never know what you're going to get, and it can help demystify the process.
Yeah. How about you, Joey?
Yeah. So first of all, I definitely echo what Eric said. You know, if you have a connection with a legislator, call them. You know, I think that's a big piece of this. If it's pushed from high up, you know, at some point you'll probably get more traction from agencies. But on a pragmatic note, what I'd say is, you know, I had a client a few weeks ago made a request from the NYPD. The NYPD said the records don't exist. So they appealed administratively, and they showed an article demonstrating that the records do exist. The NYPD said, oh, they do exist? Okay, give us 90 days. The point of this story is, if you want to be successful with FOIL with any agency, you know, and you're a regular layperson, especially with the NYPD, you really have to be persistent. In other words, a normal person would think when they get back to you and say the records don't exist, okay, I made a request, the governmental entity told me they don't exist, move on. I think the first rule is never move on. Never move on, and really be persistent. You know, it's very unfortunate, like Eric said also, in terms of it's supposed to be for regular people. Sometimes you'll get pushback. I think the most common catchphrase when they don't want to give you what they want is, your request is not reasonably described. And that's ridiculous. FOIL is not for a lawyer to draft like an interrogatory. If you speak English, you could make a FOIL request. For that matter, even if you speak a different language. I'm sure, you know, some agencies have interpreters, you could get it interpreted. There's no art like for a FOIL. People think it has to be in a certain form. It has to look like a legal briefing. I even saw the other day online, one of the legal form companies, they sell a form to make a FOIL request. You don't need it. You don't need to say pursuant to FOIL. They have an email address, they have a portal. In clear, simple English, spell out what you want, be persistent. One of the regulations on FOIL says that they have to provide someone to you, if need be, to try to break down your request so it is reasonably described, or explain to you how they hold their records or what type of records they actually have, so you could make a request that they could understand. So the law is really drafted in a way that's extremely favorable. You'll get pushback, but it's the nature of the game. And I think it's really just a matter of persistence.
Definitely. And, you know, some of the reporting at the Forward and ProPublica is a testament to what persistence can get, which is more transparency for agencies that are not necessarily interested in being transparent. So I think unless people want to drop any last minute questions in the Q&A, we'll wrap up here. I want to thank everyone for joining us for Police Reform and Accountability, how the public keeps tabs on our police system. I want to thank our panelists, Joseph Aron, an attorney at Aron Law who represented the Forward in a successful record suit against the NYPD. Thanks so much, Joey.
Thank you.
And I'd like to thank Eric Umansky, Deputy Managing Editor of ProPublica, who's written about police discipline. Thanks so much for having us, Eric.
Thanks for having me.
And you will get in your inbox, if you registered for the Zoom, a link to view it later on. It's being recorded, so you can review it and share it with all of your family and friends and interested active citizens who are hoping to get more information from their local governments. Thank you so much for joining. My name is Molly Boigon. I'm an investigative reporter with the Forward, and we will see you at the next Forward Zoominar.